Hello, good afternoon. This is Advocate.
Good afternoon.
Good
This is
afternoon,
Prem
sir.
Kohli.
Hello, everyone. Good afternoon. This is Advocate Neetu Tiwari from Ahuja Law Offices, and you are most welcome here. And we are just starting the session now. So, as we all aware about the topic today, I'm just giving you the brief, and then we'll start with uh, our guests. So, I hope my voice is audible to you all.
Yes, please.
Yeah. So, shall we? Okay, you can take 5 minutes if anybody else.
We can start.
Or we can start. Start kar. Hi, friends and colleagues. This is the second webinar hosted by Measures Ahuja Law Offices. And as you all know, that Measures Ahuja Law Offices is a boutique law firm which specialize in the field of commercial dispute, real estates, and insecticide act, seeds acts matter, etc. And we also we have also specialization in corporate advisory and other legal matters. Ahuja Law Offices has extensive experience in litigation. Today, the topic of the discussion is e-contract and its nature, validity, and admissibility. The key speaker of this discussion is Mr. T.S. Ahuja, the managing partner of Measures Ahuja Law Offices, and he has long standing with the bar for around 38 years and has a number of reported judgments of Delhi High Court and the Supreme Court of India to his credit. And the second speaker is Mr. Harvinder Singh, ex Vice President, Legal and Company Secretary, Hero Cycles and Luxottica Group. He is qualified company secretary and has experience of around 20 years in advising corporate and listed companies. So now, after the introduction, I may request Mr. Harvinder Singh, who is going to deal with the nature and scope of e-contract. So I am presenting Mr. Harvinder Singh now. Sir, over to you.
Yeah. Thank you, Neetu. Hello, friends. How are you all today?
Good, sir. Good. Thank you.
Yeah. So today is like Friday evening, so you must all be getting ready for the weekend, start of weekend. You know, nowadays after this COVID, the weekend as such has gone because now you are available 24 into 7, and the corporate culture, I can understand that everybody is facing that challenge due to COVID. So I hope you all are ready to and to understand how the e-contracts work in India, and we will discuss about the nature of the contracts and the validity and how the law are governing the e-contracts, and also on the admissibility part of it in the Indian courts, which Mr. Ahuja will talk after my session. So I would like to take you all through a presentation for this topic. Uh, One second. Yeah. Full screen. Full. So I hope you all are able to see this presentation. The first slide. Hello.
Yes, please.
Yeah. Okay. So India is not a stranger to the digital contracts, and India is by the time now in the current scenario, there have been a lot of changes in the law, especially in the last decade when IT Act 2008 Amendment Act was introduced, whereby the legal recognition has been given to the e-contracts in India. And with now emergence of the e-commerce lately, there have been a lot of thrust that e-contract should be entered. So I am discussing in this presentation that how uh, how it is easy, what are the features, and what are the validity of the contract, so that we how we can enter it, and how we can in the case of breaches or disputes, we can make it admissible in the court of law. So what are the e-contracts? So e-contracts is the mixture of contracts and internet. So it has both the nature of the both contract and the internet. Over the internet, we all know that there is no physical meetings, there is no boundaries, there is no handwriting, there is no handwritten signatures, there is lack of security. And then of course internet is so wide that ignorantly, unawareingly, many people are entering into contracts which they are not even aware. For example, like whenever you download any app or whenever you browse any website, you tend to enter by saying I accept, or by clicking an icon there. Or sometimes if you buy a software, there is an inbuilt contract into that which you have to accept to use that software or to use that website. So these are the things which a common man is not aware, that how they are entering and binding themselves into the e-contracts. And then as this act this digitalization is upcoming in India, a lot of e-commerce business is being taking place. So there is no authority per se to deal with these e-commerce regulations, though government of India has now becoming more and more active. And recently you must be knowing that there are consumer protection e-commerce rules which has given certain teeth to the current law, to give the authority some power to regulate these type of contracts. But more has to come. And then whether these contracts, if they enter by the parties, generally there is a confusion that whether they are admissible by the court of law. Because earlier, if you see in the last decade, the courts have evolved a lot on this subject. The courts have been regularly now admitting these electric documents as an evidence. So Mr. Ahuja will deal that in the following slides. And then jurisdiction is again a big issue in the e-contracts, because it is very important to decide the place of the contract or a cause of action where it happens, to understand that which jurisdiction the matter will go in case of dispute or in case of a breach. And then when you see a e-commerce transaction, there are cross-border transactions happening. One person is sitting in US, another person is sitting in Germany, one person is sitting in India. So how and what is the way to determine that where the jurisdiction lies, and how that contract or breach or dispute will become enforceable in case a party get a relief. So these are certain kind of features and the nature of the internet and the contracts which we have been facing in the current scenario. So now I will deal with kind of the classification of the contracts which we generally enter online. We have generally seen, and I think everybody in this room, in this conference, may have once or many times may have entered these kind of contracts, like like the current transaction going on the Amazon, on the Flipkart, Swiggy, Zomato. So every time you order online, you pay online, and you get the delivery of goods at your home. So it is so that is also a contract. Then there are certain products which you buy online, some softwares by order or by clicking it. And then there are services like you are buying shares, you are doing banking transactions, you are seeking financial advices. So all these kind of things or the transactions which we are doing, they all come under the e-contracts. Knowingly, unknowingly, we are regularly entering into these contracts, and we are sometimes not aware that what could be repercussions of that. And that is why you have seen that lot of discussion has been going on nowadays in India for the privacy, for the security of data. And even the India is also trying to bringing a new act on the data protection. So now, what are the type of e-contracts where we can enter? So generally we have seen there are two type of contracts. One is email contract, and the other is the website or online contracts. And if you see in an email contract, it is like a normal contract where two parties negotiate over the email. They exchange emails, they have offer, they have acceptance, and that's how they are concluded. But and in this case there is still a scope of negotiation. Parties can decide what would be the rights, obligations, and the liabilities of each party. Then the second type of contract is the online or the website contracts, where you see that whenever you go on a website, there are terms of use, there are terms of service. And you sometimes find, for example, if you download an app, you find that it gives you a type and click option, or it gives you an icon which says I accept or I agree, and you have to tick that box to use that software or you use that app. If you don't use that, then you have to leave it. So this again, when you say that I accept or I agree, it form a contract for you and the party who is offering such service. Then there are browser type of contracts, where whenever you are browsing any website, you are seeing their features. They all are kind of contracts where you admit as in you have accepted, they have made you offer and you have accepted that you want to use this website. And then there are shrink wrap contracts, which are lessly used, but generally this comes with the softwares, where you have end user license agreement with the parties, which defines that how a particular software is to be used, their licenses, their warranties, and how the resolution dispute resolution shall work in case of any dispute. So these are generally kind of e-contracts which we regularly enter. On email contracts are generally entered when both parties are agreeing to it. But website or online contracts are the type of contracts which we all, in general, knowingly or unknowingly, directly or indirectly, entering in our regular course of life. So we should all be aware that what these contracts entail to, and we should have basic knowledge that how this will help us, or in case of any breach, how we can enforce our rights. Then the question came that if I want to enter an online contract, then what are the essentials of an e-contract? So there is a good news for you who all are in the legal fraternity, and they know that how contracts are being entered in a normal parlance. So everybody in legal side of it, or who have basic knowledge of contract, they know that what are the basics of the contract. So the good part is what are the whatever is the basic of contracts is also the basics of the e-contracts. Of course, there are certain challenges in a e-contract which we'll discuss later, but the basic framework of a contract act is the same. And with the introduction of Information Technology Act also, that act has to be read in conjunction with the Indian Contract Act. Though the changes have been made in Indian Evidence Act and the Banking Regulation Act, RBI Act, but the Contract Act has remained the same even after the introduction of the IT Act. So, for example, when I say that there are certain challenges in terms of entering into e-contracts, though the essentials of the contract remain same, I would like to highlight, like for example, in case of a offer, generally when you go on a website, you generally browse at the website, and that is the invitation of offer by the seller through an advertisement to you, and then you make a offer through an email or a form online. and that is accepted by the service provider. So that's how this offer and acceptance is complete in case of a e-contract. And then of course there should be a lawful consideration for that, selling any prohibited illegal goods online, or for example if some website claim that they are selling land on the moon, so those kind of consideration will not be valid even for the e-contracts. Now coming to free consent, there is no real time interaction, especially in case of the click wrap or a browse wrap agreement where you have a standardized terms. So free consent is one of the part that how you will obtain a free consent of the other party. So in this case, Mr. Ahuja will also touch upon, but there is also a SC judgment on the LIC matter, which says that you have an option either to accept it or to leave it. So if you accept, then the person shall be prudent enough to understand that what he is entering into, and if he enter into that, then that forms a free consent or a binding contract. Then there is another feature is the lawful object. So anything illegal cannot be enforced. Anything which is violative of a public policy cannot be enforced. So this is again one feature which is available in the e-contracts. And one of the other challenges is that how to decide the age or the mental state of the other party, because the capacity of the party to a contract should be that they are competent to enter into the contract, to ascertain the age, to know that whether the person who is sitting on the other side of the computer is not a lunatic, or he is not below the age, or if we never know whether he is a minor or not. So all these challenges are there, but all said and done, the e-contracts are acceptable, and these are the basic features which can be applied while entering into the e-contracts. you know now we can discuss that what are the legal framework and validity, because one thing of course is that when you enter a contract, it defines the rights, the obligations, the liabilities, and the recourse available to the parties. So it is very important to understand that what is a legal frame or a validity of these laws in India, and whether if I enter a e-contracts, whether I will be able to enforce my rights and obligations or not. So this is also an important question. So as I told that India is no stranger, so laws have evolved over a period of time, and the Indian Contract Act is one of the base act where the essentials of the contract apply to e-contract as well. So that is the basic framework, and all other acts have to be read in conjunction with the Indian Contract Act. And then the Information Technology Act is again an act which has over the period of time built in a lot of power, or I will say a lot of teeth to these e-contracts, whereby especially section 10A of the act, which was introduced in 2008, they have given exclusive right that e-contracts can be entered, and whatever have been entered through communication online, that can be enforceable in the court of law. And then IT Act also defines certain ways that what is the time and place of dispatch. It also defines the procedural aspect also, that who will be the addressee, who will be the originator. So they have defined all and every effect of that procedural impact, that how the contracts will enter, where the place of contract will be deemed as a place. And then it also recognizes the digital signatures, where you can apply the signatures digitally, and they are accepted by the court of law. And then Indian Evidence Act, of course, which also allow the admission of the electric records in the Indian courts, which Mr. Ahuja will be dealing in the following slides. And then, of course, Indian courts have time and again in certain judgments, whether it is Shakti Bhog or Trimax International versus Vedanta, has time again made a precedent that communication through emails are accepted as an evidence and recognized by the Indian courts. So here, the legal framework and validity is already there. However, there are certain exceptions as well, which a party has to take care while entering into e-contracts, which is provided under Schedule 1 of the IT Act. The negotiable instrument other than checks cannot be entered online or through the process of e-contract. Power attorney is another document. Trust deed is another document. A will or a contract of sale of immovable property. These are certain five exceptions. Apart from them, I think everything is covered under the e-contracts, and you can freely enter those contracts. So now would like Mr. Ahuja to deal with how the admissibility in the Indian courts are done for the purpose of e-contracts and the certain case laws where the court has exclusively dealt with these matters, and then we can take the question hour session. So I am handing over to Mr. Ahuja.
Hello, friends. Thanks for taking out time to attend our session. I hope you are finding it worthwhile, and I also hope that the earlier webinar that we held, that you found it to be useful. The issue that I am dealing with pertains to the validity and admissibility of e-contracts. Now, as Mr. Harvinder had dealt with it and had stated that the terms of the Contract Act as they existed are also applicable as far as e-contracts are concerned. Now, what were the basic terms of the Contract Act? For a valid contract to be there, it was that there had to be offer, there had to be acceptance, and the contract was to be for consideration. Now, if there is any contract in which there is no consideration, or if there is no offer and acceptance, that contract is not valid, even under the Contract Act. Even in case of a e-contract, if there is no consideration which is involved, the contract will not be valid. The only thing is, the difference which is there is that, in a physical contract, the parties know with whom they are entering into a contract with. They are aware of the identity of the person, they may be aware about the name and address of the person. In case of an e-contract, you may not be aware of the person with whom you are entering into a contract. You are entering into a contract with a faceless identity. And in that particular case, one of the major pitfalls is that there are a lot of chances of you being conned into a contract. By being conned into, I mean that the person with whom you may be entering into a contract may not be the person with whom you think that you are entering into a contract. A lot of you who have been, in fact, I think most of you would be using Facebook and Instagram and Twitter or many such forums, and would be aware of that, there are a lot of people who create fake identities. There used to be a time when, the photographs as such were not put up, or even there have been cases where the photograph was different and the identity of the person was different. And you know there have been cases where men have made profiles in the name of women, and women have made profiles in the name of men, and vice versa, or otherwise. Now, same can also be the case in matter of contracts also. So this is a pitfall which is there and which needs to be avoided. Now, the issue which is there is that even if the contract is valid and the IT Act as well as the Contract Act considers it to be a valid contract, can this contract be proved in a court of law? In certain circumstances, in fact, proving an e-contract in a court of law would be easier than proving a normal contract which has been entered into. Section 65B, which was added into the Evidence Act, which deals with the as to how to prove a contract, in fact makes certain things which are easier. Now, Section 65 of Evidence Act basically differentiates between three situations: existence, condition, and contents of a document. The existence of the contract can be easily shown to have taken place once it is shown that the I agree button was pressed, or that the email was exchanged. Every computer has a distinctive IP address, and the email can always be traced to a particular person if there are regular correspondence which are taking place on email with a particular person at that particular address, or if once you have entered into an agreement with the dealer or with a purchaser or something, or there is certain communication which is going on there, then in that particular case, the that you are corresponding with that person is sufficient to prove that the email is being exchanged with that particular person. The Now, what Section 65B says is that it deals with existence and contents. Now, here there was certain amount of confusion as to while proving this contract in court, because 65B4 required that an affidavit has to be furnished by the person concerned, who can be a responsible officer of the company, to say that, as to whether this the document which is being produced, that it is. I'll just switch over for a minute and deal with whether it constitutes a document or not for a minute. Now, Evidence Act Section 3 defines a document, and it also defines what is evidence. Subsection 2 states that all documents, including electronic records produced for inspection of the court, are called documentary evidence. The Section 22A of Evidence Act says that oral admissions as to contents of electronic records are not relevant unless the genuineness of the electronic record produced is in question. And Section 45A states that opinion of examiner of electronic evidence under Section 79A of IT Act is a relevant fact. Now, what is the effect of these provisions? I'll just come to that. You see, in case of a normal agreement, when we have to prove an agreement is denied, we have to call for the witnesses to the agreement who state that yes, this agreement was signed in our presence by a particular person, or that we were witness to it when this agreement was signed, and he signed in our presence. We identify that particular person. Section 65 does away with that particular provision in case of e-contracts. In case of e-contracts or in case of e-documents. Because any document, anything which has been in the form of an electronic record produced by a computer is by deeming fiction made into a document. So wherever there is an electronic record which is made of anything, it can be a video, it can be an audio, it can be email correspondence, it can be contents of a website, anything which whatsoever is prepared as an electronic record, the same is considered as a document. And since it is considered as a document, then there is a deeming provision which says that if it is a document which is stored on a computer, or computer would include iPad, a pod, or mobile phone, all of these are taken to be computers, in or even a case of digital photography, or anything which has to be a digital mode of storage. All of these are considered to be computers, and anything which is stored in that is considered to be an electronic record. Now, in case of electronic record, so what is required to be done is that the you just have to file a copy of that electronic record before the court, along with an affidavit of a responsible person who says that these things were recorded on a computer or a mobile phone, or and the computer or mobile phone remained in his presence or in his control, or in case of the company in under his supervision, and that the uh, it was properly maintained and there was no interference in the same, and that is sufficient for the document to be proved. The the issue which arose in some of the cases was that, like, if the person who has this particular record in his possession, if he does not appear before the court and furnish this affidavit of evidence, what would be the situation thereof? And that is the issue where section 22A also plays a role with regard to oral admissions as to the contents of electronic records, because it states that the oral records cannot be considered and cannot be brought into evidence. Now, the courts have said, especially in a three-judge bench of the Honorable Supreme Court, in which since there was a dispute with regard to as to how those uh, slide how those documents are to be produced, and how those documents are to be uh, proved. The Honorable Supreme Court has said, next slide, has said that section 65 and 65B form a complete code when it comes to admissibility of information contained in an electronic record. And an electronic record by way of secondary evidence shall not be admitted unless the requirement under section 65B are satisfied, including a written certificate under section 65B4. What was further held was that, look, if the original computer or the original piece of storage which was there, in which the recording had been done is being produced, then in that particular case, there is no need or no requirement of furnishing of an affidavit under 65B4. This judgment in Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gurantia 2020 SCC Online Supreme Court 571 delivered by Justice Nariman states that makes a distinction in between which already existed in the Evidence Act as to what constitutes primary evidence and what constitutes secondary evidence. In the case of electronic evidence, they say that the computer or the mobile phone or the digital camera or the digital wheresoever it is digitally recorded, the original is produced before the court, then the same would constitute primary evidence. And no affidavit for further proving it would be required. Even a person can appear in court and say that, look, I had recorded it, or I had obtained it, or it was delivered to me. Whereas, if it has been further put into a device, like taken into a CD or a DVD or a pen drive or by some other means that it is recorded, if that is there, then in that particular case, it would be considered as secondary evidence. Any output which is taken, the original email is received, it is in your laptop, it is on your email box, that would be the original this thing. In case if a printout of the email is taken, in that particular case, then it would be output and it would be secondary evidence. So, like in the normal course, when you have to prove any document by secondary evidence, then you require a person to come and say that, look, I had made a photocopy, or I had copied this, or that the I had seen the original the original had not been tampered with. All of this requirement in the case of electronic record has been done away with. So, in fact, if it is the electronic evidence is to be proved by way of secondary evidence, then in that particular case, the only requirement which is there is under 65B4, wherein it would be that you produce an affidavit of the person who has taken the printout or who has taken a copy of it or put it in CD or in DVD or in a pen drive or any other storage facility, who states that, look, it was in that this document was not tampered with. And so what in fact section 22A says is that if the genuineness of this particular document is not in dispute, then no oral evidence is required at all. You just file an affidavit and that is sufficient. If the other party reduces the sorry, this was the timer which had been set up so that it's such a vast topic and an interesting topic, being a new one, that sometimes lawyers like me, they lose track of time. We have been accustomed to courts accommodating us without there being a restriction of time, and therefore we lose track of it. In order to keep self-control, I had put in an alarm so that I don't bore all of you with all of the discussions. Now, I'll just take a very few minutes more to. Now, another situation which can also be there is, can you just put the other slides? The other situation which can also be there is in case where the things are not on a single computer. They may be on a network, or the uh, or on a computer system which cannot be produced. If it is such a case that where it is like a number of corporates, they have a computer system which is there. Now, if the that computer system as a whole cannot be produced before code. Now, it can also be that the things may be on a network, and that network cannot be produced in code. If that cannot be done, in that particular case, the you know the only alternative left is to produce an affidavit under Section 65B4. But the thing that I am trying to say is that there are cases and circumstances in which proving an electronic record is much more simpler and much more reliable and more difficult to dispute than producing of an original document, than proving of an original document. Now, even in case of original documents, we all have come across the issues of where people have copied other person's signatures. Even in case of registered sale deeds, there have been cases where the identity of other people have been stolen and sale deeds have been executed. The contents and the authenticity of which has been denied, and so, even though there is this pitfall and a fundamental drawback that the person you are dealing with is a faceless identity in case of wheresoever there is a digital transaction which is taking place. But if maybe with the passage of time it would be there that where digital signatures have been taken, then in that particular case the digital signature, since they are taken from a recognized authority, can easily be identified and linked to the person who has made them. In fact, if some of you would notice that even some of the Supreme Court judgments these days, they are being digitally signed and they are being put up on the website. I am sorry, we are running out of time. And in case any of you would like to ask a question, please go ahead and ask it. There are certain more aspects which I had thought that will be able to deal, but the time does not permit the same. So I'm just passing it on for your questions. You may send the questions on our WhatsApp or phone numbers, or you can also mail it to us subsequently, and or you can put it on chat, and we would be happy to address whatsoever questions you have.
I hope by now you all are aware what is exactly e-contracts and what are the relevance of these type of contracts nowadays, especially in COVID-19 situation. So as Ahuja sir told us that what are the admissibility and what are the evidence, what Evidence Act or IT Act tell about the validity of e-contract or digital signature, and Harvinder sir told us about the nature and scope of this. So the basic reason for choosing this topic for today's webinar is, we are all surrounded by the contracts. We are ordering our meals from Zomato or Swiggy, and we just purchasing goods from different websites. So nowadays, or especially in this COVID-19 scenario, the globalization of the business and the main importance of e-contract are much essential for the business. So now I'm just going to thank all of you who participated today's in today's. Yeah, I'm just going to ask it, na? Or we are now thankful for all who participated in this webinar. Your feedbacks are very much valuable to us, and we look forward to receiving the same. You can send your feedback on our mobile numbers and through email. We also look forward to any suggestion that you may have with regard to the any topic or that you would like us to take up. So, if you have any question for today's webinar with regard to the e-contract or its validity or digital signature or any other thing related to this topic, you're most welcome. You can ask, please.
Well, I have a question. First of all,
Yes,
thank
please.
you so much for taking up this topic because, as we know, today and tomorrow, the world is going to be surrounded by e-contracts only. This is something which is the future now. Regarding the jurisdiction, is there any confusion so far as e-contracts are concerned, or is there any clarification which any of the acts have already given? Because I was thinking that if there are two parties sitting at a distance and entering into an e-contract, then the jurisdiction lies where? Whether victim's place or yes, please.
I'll just pass it on to Mr. Varun to answer this.
The same
Yes,
question
please.
was also asked by Mr. Himanshu Arya.
Sorry for shifting the screens. Mr. Kohli, as the question with regard to the jurisdiction is concerned, there is a section 13 of the Information Technology Acts which specifically deals with this issue. It specifically says that where the originator is, and the second is the where is the receiver. He has the jurisdiction. And if there is a multiple office of the originator as well as of the receiver, then the primary office or the corporate office, you can say, term it as registered office, that will have that area will have the jurisdiction. There is also a judgment of Allahabad High Court titled as PR Transport Agencies versus Union of India, in which the court has specifically dealt with this issue and has also dealt with the section 13 of the IT Act and has given the conclusion with regard to the jurisdiction where the originator as well as where is the receiver is. Like, I'll give your example also. Like, if you receive a purchase order from, I say, Calcutta or from Chennai, and you are based in Gurgaon, so and you have accepted from Gurgaon, then the courts of Calcutta as well as courts of uh, courts of Gurgaon will have the jurisdiction to deal with this issue. I hope I am clear with this regard to, or if you need any other input with regard to it, I'll be.
No, yes, please. It is very much clear. So either it is plaintiff's place or defendant's place. It can
Yes,
be either of these.
yes, yes.
Yeah.
Or the where the cause of action arises. Sometimes when an e-contracts, we also choose that there should be an arbitration. So the place of arbitration can be decided in the contract itself. It may
Okay.
be you can select a Mumbai, you may select Delhi, you may select Bombay, you may select. Sorry, I've repeated that Mumbai part.
In Paris.
In Paris or in
London.
Singapore or in London, like Singapore in international contracts is one of the what they usually term it as a hot cake destination for the arbitration, as well as in France. These countries are in favor of the arbitration and they are promoting the arbitration. Even the Delhi and Mumbai has also established the international arbitration centers here, and they are. You can either put the name of any of the arbitration center in the agreement, so that if there is any dispute arises, then that can be directly refer to the arbitration center to deal with these issues.
Thank you so much, sir. It is very much clear now. Thank you.
Yeah. Any further question if anyone has? Hmm.
So good afternoon, sir.
Good
This is
afternoon.
Sulabh Samay from Indore.
Yes, please.
Yes,
Sir,
Mr.
I
Smith.
with regard with the arbitration, you have just tell me about the jurisdiction of arbitration. So I will like to just confirm whether the Evidence Act applicable in arbitration,
Not exactly. Not exactly,
uh,
Mr. Samaya.
because we have filed some claim before the arbitrator, and there are some mails and some sorts of printing documents available, and we have presented before the arbitrator, and the arbitrator may reject my claim on the affidavit because I haven't submitted any of the affidavit related to the printed email I have filed with along with the claim.
You see, in fact, this judgment, the current Supreme Court judgment of 2020, which I was talking about, three-judge judgment, it says that there is no time frame as such as to when this affidavit can be submitted. So you can even file the affidavit at this particular stage also.
Okay. But
So-
it is the basic requirement in arbitration proceeding also. The Evidence Act is only applicable in arbitration.
No, Arbitration Act, you see, it's a totally different field altogether. And
Yeah, I have heard
but-
legally that the Evidence Act is not applicable so in strict manner in the arbitration proceeding.
Arbitration Act itself says that the arbitrator is at liberty to fix whatsoever procedure he deems fit for conducting the arbitration. There may be a stages where the arbitrator may say that no, there is no requirement of cross examination, and I can decide the matter only on the basis of affidavits. So it's not exactly the procedure of arbitration, the Evidence Act, or other procedural laws as CPC or other laws, which the arbitrator is bound to follow. But he is required to follow the principles of natural justice. So just take it at that, and the
Move an application for furnishing that. And he can also move an application for furnishing the evidence.
as far as your specific problem is concerned regarding the issue of filing of this affidavit, you can go through this judgment of 2020. I'll message it to you also. And there is it has been specifically dealt with that this affidavit can be filed at any time.
Okay, sir. But under Section 34 of the arbitration, whether the court can dismiss the award on the want of this technical ground of IT
No,
or Evidence Act
only,
Section 65?
only on the ground which are specified in Section 34. If the arbitrator has misconducted himself, if it is beyond his jurisdiction, if it is beyond the contract, that he has gone beyond the contract, there are limited grounds only, and it cannot
Section
go on.
34 limited ground, what they have prescribed in the Act, that is the
That's
only
right,
ground.
yes.
Okay.
The appreciation of evidence, that whether the arbitrator has appreciated the evidence correctly or not, is not within the jurisdiction of the under Section 34.
Okay, sir. Sir, but one question. My one question is that if I want to produce some videography or the photographs which my client has taken from the premises of the client, disputed property, and he taken those photograph or video on his mobile phone, and he go to the shopkeeper to just take the colored print of that photograph, and he submit the affidavit before the court regarding that the photographs he has been taken from his mobile, and just he has taken the print from the shopkeeper and just take the colored print, and the bill was also raised by the shopkeeper, and bills was also submitted before the court, and an affidavit is also submitted. So whom affidavit should be technically and legally we should submit photographer's affidavit is also jointly can be given to the court, or the party or the client
He can
affidavit,
just state that the mobile phone was in his possession at the time when the photographs were taken. The photographs were taken on his instructions, were printed on his instructions in his presence, and
yes.
he can vouch and he is producing the original mobile phone for verification before the court.
Or he can
Like
produce a memory card.
what this judgment also says is that if the original document which is there, which would in this case be the mobile phone, if it is produced, then even no affidavit under 65B4 would be required.
Okay, sir. But technically, if he did not submit the original mobile phone, he want to just submit the photographs of photocopy of photographs, or second print. Then it is not essential that the affidavit of the shopkeeper and along with the bills should be submitted before the court.
You see, if it is available, that would be good. But if it is not available, and he states that they were taken in his presence, the mobile phone was not tampered with, there were no changes which were made, and the printout was taken on his instruction, that should suffice.
Okay. Thank you, sir. Thank you very much.
Thank you. You are welcome. Any other questions, please? So, since there are no other questions which are coming, I thank all of you for your participation, and we would take leave now. And we hope that all of you will give us your feedback, and we value your feedback and would be looking forward to it.
Thank you so much, sir. Thank you.
Okay, thank you.
Thank you.